Hello, Namaskar, and welcome to this video lecture series on behalf of Project Sathi. I'm your criminal law instructor, Dr. Animesh, and I'm here with the second module, the first lecture of second module, that is general exception. Obviously, we are going to talk about a very important part of our criminal law, and that is exceptions. Exceptions, obviously, from criminal liability. So, without wasting any time, let's move forward. Okay, so general exceptions, before we begin, we have to understand the meaning of general exception. Exception obviously means exception to a rule. There must be a rule. There must be a rule for which there is an exception. So the rule here is of criminal liability. Rule जो है, whole criminal law is rule. An exception to tells those circumstances in which that rule is not applicable. For an example, very simple, suppose the rule is don't murder someone. But exception is okay, you can if it is for private defense. If it's your personal defense, you can kill someone. No, you can kill someone in self defense. You must have all heard this. Okay. So there are rules. All of the offenses are can be considered as rules. And all the things that we are going to discuss in this module are can be considered as exception. And this exception is called general exception. Why it is called general exception? General exception means it is that the circumstances, the criteria as mentioned in this particular the whole module will discuss one after the other. Today we are going to have only our introductory lecture on this. uh, it is exception. ये exception है बच्चों, क्योंकि ये हर offense का exception है. The general exceptions we are talking, it is an exception to all the offense that we have in our criminal legal system. It is not specific to a particular crime. It is general exception. यानी कि सपोज somebody has done a crime, उन्होंने crime कर दिया, it is proved, है ना, police has evidence that this person killed this person has stole this person's property, whatever they want to say, it is clear that this person committed a crime. Now exception would be such a circumstance which will which will convert that criminal act into an innocent act. वो क्या करेगा बच्चों? वो क्रिमिनल एक्ट को लेगा और जनरल एक्सेप्शन की मशीन में डालेगा और उधर से इनोसेंट व्यक्ति बाहर निकलेगा. यानी कि एक्सेप्शंस आर दो सर्कमस्टेंसेस that if they exist, there is no criminal liability. Means you have committed a crime, but because of that exception that is there, your liability will not be there. You will be exempted, you will be acquitted, you will be asked to go home. Bye. And that is the nature of general exception that we have. तो एक्सेप्शन के बच्चों चार तरीके के टाइप्स होते हैं. Obviously, first is immunity that we discussed in the last class. When we were discussing jurisdiction, we discussed there are certain people who are exempted because of the immunity they have. That is also one form of exception. That is exception of immunity. Like foreign sovereigns have immunity, like diplomats, like president, governors, army personnel, warships, all these people have immunity from law. So that is why that is an exception. Now this exception is based on the identity of the person to whom the law is applicable. If the person is a foreign sovereign, president, governor, whosoever he is, then that person is exempted from application of criminal law because of his or her identity. So that is not general exception because it's not available to everyone. Okay. Then we have two types of exception, that is justifiable and excusable. These are general exceptions. We'll discuss what is excusable, what is justifiable. But there are general exception. Number 2 and 3 are general exception. Then we have limited exceptions as well. लिमिटेड एक्सेप्शन इसलिए लिमिटेड है बच्चों क्योंकि वो स्पेसिफिक क्राइम्स पे लागू होते हैं. दे आर एप्लीकेबल टू स्पेसिफिक क्राइम्स एंड दे डू नॉट exempt the person altogether but simply reduce their liability. जैसे मैं आपको बहुत सरल सा एग्जांपल बताता हूं, देखिए जनरल एक्सेप्शन है, दो तरीके से जनरल है. पहले, इट इज एप्लीकेबल टू ऑल ऑफ द ऑफेंसेस, एंड नंबर टू, बिकॉज दे एग्जेम्प्ट अ पर्सन कंप्लीटली. सपोज यू आर चार्ज विथ एन ऑफेंस, पुलिस आपको पकड़ कर ले गई, कोर्ट के सामने खड़ा किया. अगर आप एक जनरल एक्सेप्शन प्रूव कर देते हैं, इफ यू कैन प्रूव दैट देयर वाज अ जनरल एक्सेप्शन, द कोर्ट विल आस्क यू टू गो होम. कोर्ट विल से थैंक यू, बाय, you have committed no crime. Means your criminal act will be considered exempted completely. That is why it is called general exception. But limited exception के साथ खास बात क्या है बच्चों? Limited exception is not applicable to all the offenses. They are specific to specific offenses. जैसे मर्डर का कुछ लिमिटेड एक्सेप्शंस हैं, कुछ मर्डर के, कुछ कि भाई आपने अगर गुस्से में मर्डर कर दिया, अचानक रेज में मर्डर कर दिया, तो ऑब्वियसली द लाइबिलिटी इज लिटिल लेसर. The exception is there, but that is applicable only to the murder, and the exception will not exempt you altogether from the liability, but will just reduce your liability. मतलब आपको सजा अगर ज्यादा होनी है तो कम हो जाएगी सजा, आपको छूटेंगे नहीं आप. इसको हम लोग कहते हैं कि एक तरीके से ये एक मिटिगेटिंग फैक्टर है, कम सजा होगी आपको. So limited exception is limited because of two things. Number one, it is not applicable to all the offenses, and number two, it will not completely exempt your conduct. You might still have to go to jail, but it will reduce your liability. That is why it is called limited exception. But our topic for discussion in this whole module is general exception. And when talking about general exception, we are talking about excusable and we are talking about justifiable. And we'll move on to that. What that is very interesting. Okay, nature of exception. See, some of the exceptions are make your criminal act excusable, while some of the general exceptions are of such a nature that it will make your act justifiable. अब excusable क्या और justifiable क्या? देखिए, excusable, a crime becomes excusable if the person who is committed the crime by the very lack of criminal intent is not guilty of the crime. Like, सबसे simple से example होता है बच्चों excusable का, if the person committing the crime is insane. You must have heard this, but you have seen movies, you must know if the person is insane, the person cannot be considered as a criminal. He must be insane in respect of the crime he has been committed. So if you are an insane person, then it's an excuse. You say, okay, sir, see, I have committed the crime, I killed someone, but I do not have the mental capacity to understand what is the consequence of it. We take a example that there is a person, he beheaded someone, and then he took the head of severed head of the person. सर काट दिया और उसका जो सर है, he took that head and he hid it somewhere. When someone came and asked him what you have done, so he said, no, see, I have hid his head. When he'll wake up and he'll try to search for his head, it'll be very funny. है ना मनुष्य, कैसे कि आप किसी का कोई सामान छुपा दें तो हमने उसका गला काट कर छिपा दिया, कि जब उठेगा और अपना सर ढूंढेगा तो it will be very funny. That means that person is completely insane. He has no understanding of the consequence of his action. That is something called excusable. There are other excusable offenses as well, like insanity that we discussed. There is age. If a person is less than 12 years, 7 years, 18 years, we'll discuss in that. If the person is a child, then that person's behavior is excusable. Then we have intoxication. If somebody has involuntary intoxicated you, then it is excusable. An act which is done, which is a very trivial act, is excusable. So obviously, excuses are there. And there are few recognized excuses that you can give in front of the court. Like, sir, because of lack of capacity of committing a crime, I should not be given punishment. Because I lacked the capacity of committing the crime. Because there was some fault in me or my mental condition, because of which my action should not be considered criminal. Okay. Now the second, and majority of the defenses fall under this part, that is justifiable. Justifiable is a circumstance by which your criminal action, which is criminal obviously to begin with, becomes justified. There are situations in which an act which is otherwise criminal becomes justified. Like you say, take an example, suppose police kill someone in an encounter, that is self defense. Let's say there is an executioner, जल्लाद जो होता है ना जो फांसी देता है लोगों को. Now obviously what Jallad is doing, he's committing a murder, he's killing someone, but nobody will say, oh, he has committed a murder. No, he's not committed a murder because his action is justified. Law says, yes, you are Jallad. This person has been given the death penalty. You have killed him. Perfectly all right. No problem. That is what we call justification. Private defense, self-defense, what we say, is a justification. You can say, see, yes, I killed someone. And I was capable of committing that crime. There is nothing wrong with me. I killed that person, but I do not want to be punished for the simple reason that my action is justified. Why it is justified? Because I acted in self-defense. So that is something called what we call justification. There can be the justification like consent. Like suppose somebody breaks your teeth. Somebody breaks your teeth. That is a crime. Yes. But suppose a dentist is actually extracting a teeth from your mouth, a tooth from your mouth, whether that will be considered a crime? Answer is no. If somebody random person cuts you with a knife, but if a surgeon while in surgery cuts you with knife, a normal person, you will be very angry, you will slap cases on him. But a surgeon, when he cuts you with knife, you will say, thank you, doctor. That is how it works, okay? There are justifications. If a random person gives you a slap, that will be a huge thing. But suppose your mother gives you a slap, that's fine. Nobody will say it's justification. So there are justification to various actions. So if your action is justified, it is considered as general exception or general defense that you can take. So excusable has to do with the capacity of the offender, while justification has to be from the circumstances in which the offense or the criminal act has been done. If the surgeon, let's say if he's cutting someone in his hospital bed with the consent of that person, that is fine. But if a surgeon randomly cuts someone, that becomes a crime. So justification is not about the capacity of the person, but rather the circumstance in which the criminal act is done. It is all about circumstance. Like I kill someone, not in private defense. Suppose somebody killed my friend, and next day I go to him and I kill him. Whether I can say I am acting on self-defense? No, because I am acting on revenge. But suppose if he was coming to kill my friend and then I killed him, that's fine, that's justifiable. So the crime becomes justified, so the liability will not be there. Okay, so excusable justification में excusable का मतलब है कैपेसिटी आपकी कम है क्राइम कमिट करने की, और जस्टिफिएबल का मतलब है कैपेसिटी पूरी है, बट सर्कमस्टेंस ऐसे हैं जो मेरे एक्ट को जस्टिफाइड बनाते हैं, लीगल बनाते हैं. Okay. Yes, let's talk about exception. Proof. See, whenever I interact with law students, or let's say CLAT, I have taught to the CLAT aspirant for a long period of time. Whenever I tell them a circumstance कि ऐसा हुआ तो ऐसा हुआ, तो मैंने कहा सर साबित कैसे होगा? साबित कैसे होगा? There is a whole science of evidence to actually prove something or not to prove something. But that question is obviously when you'll be in law school and you'll be learning law related to evidence, you will come to know कैसे साबित होगा, what is documentary and what is oral evidence. All those things you'll understand. But there's one thing that you need to understand, that everything has to be proved in the court. You must have heard that in Hindi movies, कानून सबूत मांगता है, so कानून सबूत मांगता है, exactly that is true. Nothing is taken on face value. There has to be proof. So just like crime has to be proved by the prosecution. Prosecution means police, the state, the government, sarkari vakil, public prosecutor. They will have to prove the circumstances of the crime. They'll have to prove actus reus and mens rea when it is required. They will have to prove all the ingredients of the offense in order to prove criminal liability. So, who will have to prove exception? Now, first of all, law presumes that there are no exceptions. If you have committed the crime, you will be held liable. But if there is any exception involved, it is the burden of the accused to prove. It is a duty of the accused to prove that there is an exception involved. Means suppose police arrested someone, suppose that person is insane. So that person or his advocate will have to prove that sir, this person is insane. Law presumes everybody to be fit and fine. If a murder is committed, law will presume that there is no self defense. Law will presume that it is a crime. If you want to prove that there is an exception, some exceptional circumstances were there, then you will have to come forward and prove that it was an exceptional act for which the accused should be given an exception, and the accused should not be held guilty. Accused should be acquitted. कन्विक्टेड एंड एक्विटेड समझते हैं आप लोग? कन्विक्टेड का मतलब दोषी साबित होना, एक्विटेड मींस रिहा कर देना, उसको बरी कर देना. तो ऑब्वियसली स्टैंडर्ड ऑफ प्रूफ मींस that the burden of proof means who will prove. So while crime has to be proven by the prosecution, the exception will have to be proven by the accused or what we call defense. डिफेंस को साबित करना पड़ेगा कि सर ये प्रूफ, ये व्यक्ति के केस में कोई एक्सेप्शन लग रहा है ना. Now let's talk about standard of proof. Now standard of proof is a very interesting thing. Standard of proof means कितना साबित करना है. देखिए बच्चों, किसी चीज को साबित करने के ना दो तरीके होते हैं जनरली लॉ में. फर्स्ट इज कॉल्ड प्रूफ बियॉन्ड रीजनेबल डाउट एंड सेकंड इज कॉल्ड प्रूफ बाय प्रीपोंडरेंस ऑफ प्रोबेबिलिटी. देखिए जनरली तीन तरह की, किसी भी चीज में तीन तरह की सिचुएशन हो सकती है. कोई भी घटना है, सपोज देयर इज अ फैक्ट, देयर इज बीन इंसिडेंट, है ना, और आपके सामने कोई आता है कि सर ऐसी घटना हो गई, XYZ हो गया. ओके, नाउ it can be proved by three ways. It can be proved, three standards of proof can be there. First, it can be proved, yes, that it is certain, it is beyond all reasonable doubt that this has happened in this way it has happened. When you are absolute about something, absolute means there is no doubt. There is no doubt that this is what has happened. That is what we called proven beyond all reasonable doubt. On the other hand, if something is, it is proved that it has not happened, absolutely not happened, it is considered as disproved. Disproved का मतलब है बच्चों बिल्कुल ही पता ही नहीं, बिल्कुल ही झूठ निकल गई वो बात. जैसे कॉन्स्पिरेसी थ्योरीज होती है ना कि भाई ऐसा ऐसा हो गया, इसका कोई बेसिस नहीं होता. दैट कैन बी डिस्प्रूव्ड, दैट कैन बी फैक्ट चेक्ड, दैट इट इज एब्सोल्युटली जो है झूठ है वो बात. And there are there are evidences to point that that thing didn't happen. You know, you must have seen the meme culture. लोग आते कहते हैं मुझे से एक ऑटो वाला मिला, उसने ऐसा बताया. लोग कहते हैं that things that didn't happen. All those things that generally written on Instagram and Twitter and all. So standard of proof क्या है बच्चों? Standard of proof में तीसरी चीज जो होती है वो होती है कि भाई something in the middle, that we cannot be absolutely 100% sure that this happened, but we cannot be 100% sure that it didn't happen. So it is something in between. So in this case, we'll have to determine whether it is likely or not likely. Whether the proof is beyond 50%, मतलब 100% तो नहीं है, पर आप कहते हैं हाँ 80% संभावना है कि ऐसा हुआ होगा. It's a possibility that 80% that this has happened. At the same time, on the other hand, it can be no, the possibility is less than 50%. It is more likely that it has not happened. So it is all about likelihood. Okay. So let me talk to you about standard of proof. When we are proving the guilt of the person, यानी हमको किसी को दोषी साबित करना है. In that case, the burden that is on the prosecution, जो सरकारी वकील या पुलिस को साबित करना है, that is beyond all reasonable doubt. You must have heard that particular saying that let 100 criminals walk free than to punish one innocent person. 100 दोषी लोग छूट जाएं वो चलेगा, बट एक निर्दोष को सजा नहीं होनी चाहिए. That is why we have this beyond all reasonable doubt standard. Beyond all reasonable doubt. It means that if prosecution is trying to prove the guilt of any person, they will have to prove beyond all reasonable doubt. Meaning thereby, they will have to make sure that the court is 100% sure that the person has committed the crime. If there is a room for some doubt, कोई थोड़ा सा संदेह है कि भाई हो भी सकता है ना किया हो, शक हो गया आपको कोई, है ना, तो फिर in that case it will become that person will not be convicted and that person will be released. That is why some people say कि अरे भाई भारत में 100 cases चलते हैं तो उसमें there is an 80 to 90% acquittal rate, not 100%. So very few people get convicted, है ना. 15%, 20% people are convicted of a crime. Generally people are acquitted. Why acquitted they are? Not because they're innocent, but because the prosecution, the police, failed to prove their guilt 100%. है ना, आपने सुना होगा इसको सबूतों के अभाव में छोड़ दिया. सबूतों के अभाव में छोड़ दिया मतलब that there was evidence against that person, but that evidence was not sufficient to convict him. संदेह की जगह थी, there was some ground for suspicion. If there is suspicion, somehow suspicion, if there is single unexplained circumstance, you will have to acquit the person. You know? But let's say there is the prosecution has discharged the burden, means they have 100% proved that this person is guilty. And now the ball is in the court of accused. Now that accused will have to prove exception. If there is an exception, obviously, if you're a lawyer, if you're a defense lawyer and you want to get acquittal for your client, and the prosecution 100% prove, उन्होंने सीसीटीवी कैमरा 5 विटनेस लाके खड़े कर दिए, उन्होंने कहा हाँ सर इन्होंने ही मारा है. Now what you will have to do, you will have to prove existence of an exception, but that exception you will not have to prove beyond all reasonable doubt. यानी 100% आपको प्रूफ नहीं करना है. It will have to be proved by the preponderance of probability. Preponderance of probability means you will have to show to the court that it is more likely that an exception is there than the possibility that there is no exception. यानी you will have to prove 51%. आपको साबित करना है कि सर एक्सेप्शन होने की संभावना ज्यादा है और नहीं होने की कम. If this much you can prove to the court will acquit the accused, will give him the benefit of that exception. By the same rule, 100 guilty person can be acquitted, but one innocent should not be punished. That is why in order to protect that person who is on trial, and there is a likelihood that an exception was there, है ना. अब सपोज किसी पर सेल्फ डिफेंस का आरोप है, उसको भी 2-4 चाकू के घाव लगे हुए हैं, and he's also in hospital and somebody has been killed. This person says कि सर वो पर्सन मुझे मारने आया था, फिर मैंने उसे मारा, और सपोज उसके पास भी एक वेपन था, तो ऑब्वियसली लग रखता है कि भाई हो सकता है, संभव है कि एक्चुअली ये व्यक्ति सेल्फ डिफेंस में ही हो. तो इन दैट केस द कोर्ट विल एक्विट. If it is more likely that there was a general exception, yani in 100% cases you cannot say that somebody is an insane. But suppose somebody has a medical history of insanity, his behavior was erratic, everybody complained that okay, his behavior was very problematic, he was likely insane, he was behaving in a very insane manner. The court will say that it is likely that this person is insane. मतलब 100% तो हम श्योर नहीं है, you cannot go inside the brain of someone to prove whether a person is insane or not. But if the court considers that this is more likely that this person is insane than the opposite of it, then the court will accept that exception and will acquit that accused. So standard of proof, while proving guilt, is beyond all reasonable doubt, but while proving exception is not beyond all reasonable doubt, but it is only likelihood. What we call preponderance of probability. What is more probable? If existence of an exception was more probable, then the defense will be given. If the non-existence of the exception is more probable, then exception will not be given. That is how it works. Thirdly, what we call pleading exception. Pleading exception means um, simply uh, whether exception has to be specifically pleaded. General answer is yes. Obviously, the court presumes there is no exception, and a person who has committed an act will be held liable, will be held guilty. But if there is evidence to indicate that this person, that some exception might be there, अगर बिल्कुल सामने सामने एविडेंस में दिख गया कोर्ट को, प्राइमा फेसी दिख गया, पुलिस के रिकॉर्ड में ही दिख गया कि सम एक्सेप्शन इज देयर, दैट पर्सन हैज बीन डायग्नोस्ड विद सिजोफ्रेनिया, और दैट पर्सन अगर सपोज कोर्ट के सामने वो बिल्कुल 10 साल का बच्चा लेकर के चले आए और कहा कि सर ये बच्चा जो है इसने रेप कर दिया किसी महिला का, तो ये 9-10 साल का बच्चा है, ही लुक्स वेरी यंग, सो द कोर्ट विल इंक्वायर इनटू द फैक्ट दैट व्हाट इज द पर्सनस एज. अगर कोर्ट और फिर अगर आ गया कि भाई ये व्यक्ति सेक्सुअली कॉम्पिटेंट ही नहीं है, 9 साल का बच्चा है, तो कोर्ट विल से व्हाट इज नॉनसेंस इज दिस, एक्विट दिस पर्सन. सो इन दैट केस एक्विटल विल बी देयर, है ना. सो एक्सेप्शंस में ध्यान में रखना है कि व्हाट इज दी, whether the exceptions have to be specifically pleaded. The general answer is yes. But if the court observes that there is an exception and it is apparent on the record, बिल्कुल सामने सामने दिख गया कोर्ट को, so in that case, court can, even without defense saying that there is an exception, the court can give benefit of exception to the accused. Even High Court or Supreme Court. Sometimes people don't have access to a very good lawyer. You know? Many poor people, they lack proper legal representation. अच्छे वकील महंगे आते हैं. That is why Bar Council or legal fraternity, we as teachers urge every student who takes the law as profession कि भाई give some time for pro bono work. Pro bono means be the voice of the voiceless. So even if you are law student right now, but you make a resolve that okay, some time, some working time, 10% of your time, 20% of your time, you will give for the pro bono work, for helping others, those who cannot afford quality legal representation, give them some quality legal representation, give them some good um, representation. So many case it happens that there is a clear case of exception, but the good lawyer is not good. He didn't plead. Matter reached High Court or Supreme Court, and in Supreme Court, some good lawyer takes that case and they plead it. So in those cases, even Supreme Court or High Court, sometimes they give this benefit of exception to the accused, and they acquit them. Okay, so this is called proof of exception, pleading. Whether the pleading means it has to be argued specifically or not. General answer is yes, but even if it is not specifically argued, Supreme Court can interfere and give the benefit. Okay, so this is about introduction of general exception. Next we'll learn mistake. Mistake and legality we'll discuss. We'll start with the defenses. Okay, I hope you got some idea about general exception, the introductory part of it. From tomorrow, from the next lecture, we'll start with the different exceptions in various classes. Obviously, you know how to reach me, animate@mpdnu.ac.in. So I'll be very happy to assist you further. So I'll meet you in the next class. Thank you so much. Thank you so much for being patient listeners. See you then.